Welcome back, everyone. I know you're going to remember this next case. This one is another high-profile murder trial. It involves 18-year-old Kyle Rittenhouse, with jury selection set to begin Monday. Now, the reason that name probably rings a bell to you is because he's the one who's accused of killing two men and injuring a third during protests in Kenosha, Wisconsin last year. But the judge presiding over the trial has already made several questionable rulings this week. The judge has decided that the men shot by Rittenhouse cannot be referred to as victims during the trial, but he ruled those same men could be called rioters, looters, or arsonists. Listen to this.
The word victim is a loaded word. And I think alleged victim is a cousin to it. Let the evidence show what the evidence shows, and if the evidence shows that any or more than one of these people were engaging in arson, rioting, or looting, then I'm not going to tell the defense they can't call them that.
I know you're also going to remember the video of him, Kyle Rittenhouse. He was walking through the streets of Kenosha, Wisconsin, armed with an AR-15 style rifle, walking right past police, in fact. Well, he's accused of killing Anthony Huber and Joseph Rosenbaum and wounding Gage Grosskreutz. But his attorney claims that Rittenhouse was acting in self-defense. Back with me now is Maria Banjo and Karen Nance. I really want to get both your take on this judge's ruling, so thanks for staying with us. I just don't understand the judge's rationale with these rulings. He's preventing, the use of loaded words like victims, of course, in a trial. That's understandable. But then turns around and says you can use rioters, looters, or arsonists. Aren't those loaded words? Karen, I'll start with you.
I believe those are more loaded than the word victim. And it shows extreme prejudice on the part of the judicial officer, and it's grounds for an appeal. That's my opinion. It's just absolutely ludicrous to not be able to refer to people that have been shot and two of them that have been killed, that they are not victims. And I'll Maria read on it. It's just ridiculous.
Maria?
Yes, I agree. I was shocked when I ended up reading an article about this ruling because I've seen defense attorneys attempt to prevent prosecutors from using the word victims. I've never seen a judge side with such a request. It's absurd. I am shocked. I think it's highly, highly prejudicial for the defense to be able to refer to the victims in any of those ways. At the end of the day, it's clear what the defense is trying to do, trying to paint the victims here as folks who are criminals, therefore that they are justified, or Kyle is justified in killing them. And we know that vigilante justice is not how we do things here in America. He's not allowed to just execute people on the street. And at the end of the day, this case screams white privilege. I'm hopeful that this ruling isn't the start of how the rest of this trial is going to proceed.
Yeah, I mean, it's so obvious. I mean, it's preposterous. But anyhow, so the judge says the men killed by Rittenhouse can be called rioters and looters if evidence allows. We know one of the men he shot, the one who survived, was actually a street medic, and he hasn't been charged with a crime. So what would the defense need to prove to be able to refer to these men as rioters and looters? Karen?
If there is any type of video or information from other witnesses that they saw them engaged in what can be, starting a fire, involved in some type of altercation directly with the police, they can make that argument that either they have a witness that would testify to that, and or they have video showing that. I'm not sure if they have that. And then hopefully the court, in looking at that evidence, will make a just ruling. And people have a First Amendment right to protest. And so I don't believe, to my knowledge at this point, that there's anything that's going to support an allegation that these people were engaged in conduct that rises to the level of arson or rioting.
Maria, what do you think?
Yes. I mean, when it comes to this particular defense, the defense has to prove that Kyle's perception was reasonable. And in order to do that, at the end of the day, the defense is not really concerned about whether or not these victims were in fact committing crimes, whether or not they're trying to prove whether or not they can cobble together sufficient evidence to prove that from Kyle's perspective, it was justifiable and reasonable for him to think that they were committing a crime, even if he was in fact incorrect. And so, what really matters is what a reasonable person would have done in Kyle's position. So, I do think that what they're going to have to show is they're going to have to show independent evidence that demonstrates that it appeared that the victims were committing a crime. But again, without knowing the local law, I'm not sure whether or not that is even sufficient basis for defense.
Okay, so then this isn't the judge's only controversial ruling. Back in September, he ruled the jury for this trial will not hear evidence allegedly tying Rittenhouse to the Proud Boys, nor would they see video evidence of him punching a girl just weeks before that incident happened in Kenosha. Karen, what's going on here?
It sounds like the judge has made a decision, right, about the innocence, which he is totally inappropriate to do. But that is directly on point because Rittenhouse indicated that that was the motivation. He had Facebook and other information that indicated that he was acting as part of the Proud Boys or at their insistence. And the other information with regard to the it goes to his propensity for violence, and those are extremely relevant factors, especially given the facts that we have in this case.
Well, ladies, thank you both for your poise and professionalism discussing these very obviously bizarre situations here that have happened. Thank you so much for being with us tonight.